Good evening, ladies and gentlemen. Dear colleagues and friends of the Käte Hamburger Center, Law is Culture. Welcome to today's lecture, our forums evening, by our speaker, Dr. Rafael Mrowczynski. I do hope that I pronounce your name correctly, from Leipzig. His talk is titled, very suspenseful, You Eat What You Kill, Practicing Law and Making a Living in Post-Socialist Market Economies. I was starting to talk with somebody who said, is it appetizing? So we'll see how appetizing it is. The law in the books needs to be brought to life. Justice may only be achieved by the law in action. Legal rules have to be applied to certain specific cases, and the law has to be interpreted. This requires certain actors, not only judges who hear the cases, but also lawyers who argue their cases in court. Also legal practitioners who provide advice to laypersons and argue in court, be it defense attorneys in criminal proceedings, be it advocates in civil cases, where private parties seek redress for damages against each other. But representation may also be required where actions can be brought against the government, as is the case in states where the rule of law prevails. Moreover, both in private and the public sector, legal advice is often required even before going to court, and companies as well as the government therefore employ in-house counsel and legal professionals. Thus, lawyers play a very significant role in the administration of justice. In order to fulfill this role and this special function, the legal profession is usually regulated in specific ways. This starts with a question: what kind of an education do you need? Is it necessary to study the law at a university, at a specific law school? Whom may provide legal advice or act in the court on behalf of a client? How is access to the bar restricted? What qualifications does this require? But at the same time, legal professionals, just like any other professionals, provide services. And by doing so, like others, they need to be making a living. And some of them actually make, as we know, quite a good living by that. So, however, the lawyer's interest to earn a satisfactory living, or maybe even rake in money and getting filthily rich, this might get in conflict with the lawyer's responsibilities to the client, to the legal system, or the prevailing morals in remaining an upright person, a conscientious lawyer. How this conflict is resolved or regulated varies widely from one state and legal community to another. In some, indeed, lawyers eat what they kill, and they are allowed to do so, in fact. Whereas in others, remuneration as public servants or servants to the justice is strictly controlled. From a comparative perspective, there are significant differences regarding the degree of state regulation or self-governance of the legal profession. Self-regulation helps maintain the legal profession's independence from government domination. An independent legal profession is an important force in preserving the rule of law. For abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for the right to be able to practice. Often the legal profession enjoys a larger degree of autonomy than other professions. This relative autonomy carries with it special responsibilities of self-government. The profession itself has to ensure that its ethical rules or codes of professional conduct are conceived to be in the public interest and not in the furtherance of the self-interest. Having said this much, as a legal scholar, I think the legal profession for social scientists is really a very interesting object of research. And this is in particular the case in times of systematic change, like those that we have recently witnessed with the collapse of state socialism in Central and Eastern Europe. Tonight, now we have the chance to gain insight into the sociologist's perspective on how, in the emerging post-socialist market economies, Polish and Russian legal practitioners are in fact impacted by being economic actors now. Using autobiographic narrative interviews with Polish and Russian lawyers, Rafael Mrowczynski has explored how being economic actors has shaped their social orientation and guided their professional activities. So this is a really, really fascinating and topic that I'm very much looking forward to hearing more about. But before I will give the floor to you, I would like to introduce Dr. Rafael Mrowczynski. He is a sociologist and postdoctoral researcher at the Institute for Cultural Studies at Leipzig University. He studied political science at the Goethe University in Frankfurt and graduated with a thesis on John Locke's political philosophy. Subsequently, funded by a grant of the Heinrich Böll Foundation, he then pursued his PhD studies and obtained a PhD in sociology at the University of Hanover with a thesis on middle strata in late Soviet and in Russian society, already working in his current field of specialization. Russia and Eastern Europe have been the focus both of his research, where he has published widely in a wide variety of journals and book reviews, book chapters and so forth, as well as in his other activities, such as political consulting, for example. He has worked extensively in a number of capacities in both Russia and Poland. From 2010 to 2015, he was assistant professor of the German Academic Exchange Service, the DAAD, at the Faculty of Sociology of National Research University Higher School of Economics in Moscow. He was also visiting researcher at the Institute of Sociology of the University of Warsaw, doing empirical field research. I think part of this he will present today. And most recently, he worked as a research fellow at the Otto Suhr Institute of Political Science at Free University Berlin, Germany, where he prepared a collaborative research proposal on tax administrations and bureaucratic cultures in post-Soviet countries. And now, since April 2018, Rafael Mrowczynski is a fellow at our center, and we are very happy to have you here, and we are very much looking forward to your presentation. Yours is the floor.
So thank you very much, Professor Detler, for introducing me. I'm very glad to be here, and I would like to express my gratitude to the entire team of Käte Hamburger colleague here in Bonn for letting me work in this wonderful intellectual atmosphere. But I'm also very grateful because on this long way that I'm going towards the second dissertation we have in Germany, you have to apply for funding, and usually you have to twist your topic somehow into the grant program frames. And when I started to write a proposal for Käte Hamburger colleague, I realized that it's not twisting, it's helping me to get a focus on something that is also the focus of your collaborative work in the next few years. It's the relationship between law and economy, and I hope that I will be able to contribute a little bit to our discussions on this topic. So this is the map of the presentation. I think I will try to be very very brief on some points, also because in your introduction, Professor Detloff already touched upon several very important issues. So I will start with a sociological look at professions as a linchpin between law and economy. Then I will turn to post-socialist transformations and law. I will talk a bit about varieties of post-socialism and focusing on Poland and Russia, which is kind of justification of why I selected these two country cases. I will say a bit about methodology, but only very briefly. And then I proceed to my empirical findings, which are, of course, still work in progress. So practicing law, as Professor Detloff has already mentioned, is a professional activity. So it is something that happens at least when we look at legal professions, what happens at the intersection of law and economy. And of course there are different dimensions of this research focus. You could think about legal regulation of economic activities, but as I already mentioned, practice of law is also an economic activity. And I would say for all lawyers, not just for those who are out in the market, because also academic lawyers, they also do their living, they make their living through a certain form of being involved in social division of labor. So here we're coming to very fundamental topics of sociology. So it's professionalism is a specific phenomenon of social division of labor, especially in organic solidarity types of societies. It has something to do with what Niklas Luhmann would call functional differentiation in modern societies. And these are ideas which are probably familiar to some of you. Maybe less familiar is an idea coming from Ulrich Oevermann, a German sociologist and social psychologist, about professional activities being the process of vicarious solving of agency crisis. So you consult professionals when you are unable to continue with your own life practice. So if you get ill and you're so seriously ill that your self-medication doesn't help, then you turn to someone who's better, who's an expert in this area. And something similar, but in a very different constellations, is what legal professionals do. Of course, as Professor Detloff already mentioned, it's about making a living in a market environment. So that's where this idea, which you sometimes find in English-speaking discussions about you eat what you kill, so you are responsible for your own income. You are, or at least a part of legal profession is still the so-called free profession. So it's a question of economic survival and profit maximization, which could come into potential conflict, but not necessarily, with ethical implications which result from this vicarious solving of agency crisis, where you take responsibility for restoring agency abilities of your clients. And the most common but very diverse, historically and internationally very diverse answer to this problem is something that Elliot Freitzen, a sociologist of professions, called the third logic, professional self-regulation, which is different in its character from pure market regulation, because it's an ideal type of market regulation is whoever makes a claim to professional expertise and finds clients is a professional, and to state regulation. So let's look more closely at some sociological conceptualizations of professionalism, because it's a topic that has been for decades in the very center of sociological interest, and most of prominent sociologists have made some interesting statements and shared some interesting ideas with us on professionalism. For example, functionalists and neo-functionalists like Parsons and Överman, they emphasize that professions are dealing with particularly important social, human problems on the basis of expert knowledge, usually scientific knowledge or scientific-based knowledge. Their activities are related to case social values and human values like health, in case of medical doctors, justice in case of lawyers, or truth in case of scientists, although many scientists abstain today from referring to the idea of truth. But I think without truth, the whole business of science doesn't make sense. Överman's neo-functionalist idea, which I already introduced, is already an answer to critical theories of professionalism, which were advanced by authors like Sarfati Larsson or Abel, specifically in the domain of legal profession, where they mainly look at professional groups as groups that practice social closure. They try to exclude outsiders, they try to obtain monopolistic position in the market, obtain monopolistic rents, and also secure their high social prestige by excluding outsiders. And they do it mainly through control over what these theorists call production of producers of professional services. So they try to control the systems of education, of theoretical and practical education. I would rather speak of a cartel than of a monopoly, because you still don't have one single provider, one single actor. You just have many different lawyers, but of course they have to be licensed by the professional organized profession to be admitted to a particular segment of legal services market or any other professional market as far as it is regulated. Then there is an interesting idea, a distinction between scientific professions and normative professions, which was advanced by Terence Halliday. So the idea is that there are two different types of knowledge bases, a rather descriptive scientific, natural science based knowledge, which is characteristic of medical doctors and engineers, and in case of lawyers or, for example, theologians, it's more something normative, prescriptive. Also, some social ecologists like Andrew Abbott, they look at professions as a system of different occupational groups which struggle over professional jurisdictions, so over domains of occupational activities which are their exclusive domains. And you can think about, for example, when you look at science, then you can think about different disciplines competing over better explanations of certain phenomena. If you think about crime, where, for example, lawyers, sociologists, psychologists, neuroscientists advance competing claims, and this, you could also understand it as a kind of struggle over jurisdiction. Who is the best explainer of this phenomena? And we also have similar processes going in other professional fields, for example, between tax advisors and lawyers, etc. Socio-historical studies by authors like Baric, Ziegrist, Krause, they looked at comparatively at different countries, and that's where I'm very much indebted to them, because they advance the idea of different processes of historical processes of professionalization, of creating professional institutions, the professionalization from below, which dominated the history of professions in countries like US and United Kingdom, and professionalization from above, where state bodies and state power played a much greater role in instituting and incepting institutions of professional self-regulation, which was characteristic of most of the continental Europe, and it also applies to countries of Central and Eastern Europe, as I will explain later. And then we also have system theory, which also made a contribution to theorizing on professions. So professional systems from this perspective are systems where there is no generalized media of communication, as Luhmann puts it. So a generalized media of communications, for example, money in economic system. You can evaluate different projects based on profit, on money that they generate. And in case of professional systems, there is no such a media of communication. You have to evaluate case by case, and that's why also individual professionals and their abilities become more important. But my personal preference lies with Pierre Bourdieu's field theory. And I think that this frame is also able to accommodate a lot of things that I was talking about before. So social function and specialization is constitutive for professional fields where particular problems of society members are solved or at least treated somehow. And this relates to what system theorists call a system-environment divide. Different forms of cultural capital are a conceptualization of different knowledge bases and different operational principles, which were also addressed by Halliday in this distinction between scientific and normative professions. Struggles between fields, and this is something that's at the very center of Bourdieu's theory, so you could say that's something that relates to struggles over jurisdictions, but also within fields where different professionals from the same specialization compete with each other and try to take most advantageous positions, and they re-evaluate their different forms of capital in this process. Self-regulation, the third logic, is certainly a powerful mechanism of demarcating field boundaries, which is related to social closure and to attempts of monopolization. But there is also the idea of habitus, which is particularly interesting for me as someone who's interested in finding a link between structures and agencies and bridging the gap between institutionalism and interactionism. And Bourdieu himself, he wrote a very interesting paper on juridical fields in late 1980s. So this, I would say, it's one of the most fascinating, most interesting pieces of writing in sociology of law at all. Now let me turn to post-socialist transformation and law. So in 1989 or 1990, when state socialism collapsed, the process of fundamental political changes has started, and this process is connected to a shift towards something that Harold Berman calls law-based state. So it's his translation of Rechtsstaat. I mean, most people would use rule of law here, but I follow his argument, which was very convincing, that the idea of rule of law is very deeply rooted in the tradition of common law, and that the continental tradition of Rechtsstaat is a bit different, and that's why he proposes this different concept. But in any case, and for most of you, it's nothing really novel. It's about political and it's about control or legal control over political and administrative activities of different state agencies. But there was also a fundamental economic change from centrally managed or so-called planned economy to market economy. And this process had important implications for law. So on the one hand, on a micro level, there was an increased need in normative regulation of decentral transactions. So contracts, civil law, all the whole area of law, this domain of law regulates the microstructure of economic interactions. And of course, there are big regulatory frames for markets or market segments, which are also law, legal norms. So what are the implications for the profession? One is, of course, the growing importance of this legal profession is also reflected in an explosion of institutions of professional legal education that took place in, as far as I'm aware, all post-socialist countries, with growing number of students and also growing numbers of mainly commercial higher education institutions. And it's also a process of partial marketization of juridical fields, which is connected to the rise of private practice of law, which may mean that within the juridical field, the economic logic of action is increasing. Now let me turn to a comparison between Poland and Russia, and I hope you understand its bare bones. What I'm going to present here, it's, I mean, one table for period from 19th century to present. In late 19th century and before the First World War in Russia, we observe an indigenous autocratic state, as I call it, with some weak elements of law-based state introduced after the reforms of the 1860s. Poland didn't exist at this time, so the territory of Poland was partitioned between three empires: the Russian Empire, that's the direct historic entanglement, Prussia and later Germany, and the Austro-Hungarian Habsburg Empire. And during the partitions, in some parts, autocratic law-based states, especially in German and Austrian area, were introduced. After before the Second World War, which means after the First World War, there is a clear divergence of paths. In Russia, after the October Revolution, you have a period, a rather short one, of legal nihilism, which was then followed by a process that I didn't mention here, by a new economic policy, where there was a kind of revitalization of the legal system, but then Stalinist terror and the establishment of a socialist dual state followed. I borrowed this concept of dual state, of course, from Ernst Fraenkel, but I'm not the first one who made this connection. I think the first one was Robert Charlotte in the 1970s. In Poland, at the beginning, there was a liberal democratic model, which then turned into moderately autocratic state after 1926, after Marshal Pilsudski took over power, and the period of liberal democracy was ended. After the Second World War, in Russia or Soviet Union, we observed state socialism with socialist dual state, which developed in a different direction as in Frankel's case in Germany. So it was rather the strengthening of the normative state component vis-a-vis the prerogative state. In Poland, there was a similar basic frame, but the difference was in many regime compromises that the regime made, especially at the time when state socialism was established in Poland, because of the strong resistance of large sections of the population, but nevertheless massive popular resistance never faded away, and in the 1980s, in the early 1980s, it even reached its pinnacle when the movement Solidarność or Solidarity was created. While in the Soviet Union there was rather little political resistance and quite a lot of acceptance for state socialist model, especially in its post-Stalinist non-terrorist version. So we have a different starting situation in 1989, 1990, that in Russia we basically have no counter-elites. Those who started transformation are actors coming from this party-state apparatus. Nevertheless, there is an attempt of shock therapy, which was also a very radical, now it's called neoliberal reforms, which were, however, stopped quite quickly, and it turned into a process of insider privatization and process which I call state fragmentation, which does not merely mean that Soviet Union fall apart, but also within Russia there was a process of partial privatization of different segments of the state. So like police officers or tax officers working more on their own than, or for regional for regional administration than for the central federal administration. And this process was stopped and reversed after Putin came to power, and now we see something that's I would call a rise of an autocratic dual state. While in Poland the process was quite different. The transformation was negotiated with a counter-elite which emerged from Solidarność movement. There was also a shock therapy which was quite consequent with some hardships at the beginning, which are unquestionable. There was rather a state continuity with little of this fragmentation phenomena. I'm not saying that they were non-existent, but they were much weaker as compared to the case of Russia in the 1990s. And there was a process of developing a liberal multi-party democracy with rather weak political capitalism. And another important factor which distinguishes these two cases is EU accession and the strong push toward law-based state. However, in the last few years, for me the question arises, is Poland on the way towards a kind of national conservative dual state, and are the judicial reforms that were introduced by the Law and Justice government or peace are pointing in this direction? As most of you know, we have an excellent expert on this question who is unfortunately not present here, I mean Marta Buchholz. And I very much benefited from discussions with her on this topic. Okay, so I will speed up a little bit, and I will not walk you through all of this slide. I will just tell you briefly how legal professions were organized in the Soviet Union. So there were, after 1930s, there were so-called colleges of the bar, which you could roughly compare to chambers of advocates which exist on the regional level. One important thing when we talk about Russia, there is in Russia the concept of jurist, of someone who is trained in law, is very broad, and it also includes graduates from police and state security academies, which has implications of what kind of personal rotations and movement between different occupational groups is possible. In Soviet Union there was a institutionalized jurisdictional divide, so advocates or attorneys at law, in Russian advokaty, were responsible for doing work, mainly courtroom-related work for private individuals, and they worked in quasi-collectivized forms of private legal practice. Their fees were very strictly regulated, but nevertheless they were one of the very few officially non-state employed occupational groups. Most of the lawyers who worked in the Soviet Union were working for state or centrally managed companies, so they were salaried employees, the so-called jurisconsulti, and they mainly worked not in courts but in special state arbitration committees which were regulating disputes between different units of the centrally planned or centrally managed economy. What happened in the 1990s, or already in the period of so-called perestroika under Mikhail Gorbachev, was a spontaneous or de facto deregulation of the legal professions. So on the one hand, there was a rise of so-called legal cooperatives. So cooperatives was a code word for nascent forms of private entrepreneurship, but the name was suggesting that it's still collectivist, socialist, but in fact these were just people doing business together. And many of these legal cooperatives, I interviewed lawyers who worked in them, and they were also baffled by the fact that many of the people who established this cooperatives were not lawyers at all. So one of my interviews worked for a cooperative which was run by a trade union official and a medical doctor. So for some reason, and many of them, they were practicing basically they went to professional lawyers, to advocates. They paid 1 ruble at this time. A consultation for something like half an hour costed 1 ruble. So an engineer in late Soviet Union would make something like 220 rubles a month. So you pay 1 ruble, you get a consultation. So they did it for companies, and then they sold the results of the company for, let's say, 5 rubles. And but many people thought it's prestigious that you are now serviced not by this old-fashioned advocates, but you're serviced by a legal cooperative, which was, you know, trying to look like a Western law firm. Then there was also a rise of parallel of alternative or so-called alternative colleges of the bar. So they were established by people trained in law, but many of them came from either law enforcement agencies, because, as I said before, people who were trained at the police academy or state security academy of the KGB were considered to be lawyers. They had a degree in pravowiec, so it's in jurisprudence. And many of these new parallel alternative colleges were established by this kind of actors. And there was an explosion of number of different lawyers and advocates. So the number of advocates grew in the 1990s by a factor of 3 or 4. And nobody knows how many people are in private unregulated practice in Moscow or in Russia today. So the estimates by the Russian Ministry of Justice are so widespread that you know, for Moscow they say between 50 and 150,000 people, which means that they don't exactly know if, you know, the spread is that big. So the outcome in Russia is the reign of free market. So you would say the first logic prevails, in terminology by Elliot Frazen. And there is no effective social closure. However, in 2002, so already in early Putin period, there was a reintegration of the bar. But this is just an island. That's a professional island with strong state supervision in an ocean of unregulated practice. Okay, let me move to Poland. I will just pick up these issues here lower. So in Poland, there was a limited self-regulation of the bar during the state socialism. It was a kind of shelter within a bureaucratic system. And there was a similar system of collectivist practice, which in fact was a stealth for individual practice. So one of my interviewees said that his collective was in fact a conglomerate of solo practitioners. So this collectivist factor was just a front. Big difference is that in the 1980s, and this is remarkable because this strengthening of professional self-regulation came at the time of the martial law. So when the oppositional movement Solidarność was suppressed, but nevertheless the government extended the self-regulation of the Polish bar, and also created the first elements of self-governance of the second professional group of in-house lawyers who at this time were working exclusively in state-owned companies. And now we are moving to the 1990s and 2000s. So in this time, the legal counselors, so these in-house lawyers, became, as I call it, advocatized. So they were becoming more and more similar to private practitioners. So many of them started to run their own law firms or practice on their own. So they were not exclusively employees of state or emerging private companies. They started to work in service for fee practice. And they were also expanding their jurisdiction, which means that at the beginning they were only allowed to represent their clients in business-related cases. Then they were made some forays into family law. At the beginning it was just uncontested divorce, later contested divorce without child custody issues. Then child custody was also included in their jurisdiction. And in 2015, so 3 years ago, they were also admitted to criminal defense, and from this moment on, we basically have two professional groups. They do the same, but they have different names: advocaci, advocates, and radcowie prawni, legal counselors. And due to this historical different processes, how they emerged, and due to, let's say, present day distinctionary struggles, there is no unification despite de facto homology. So just to round it up, so this is, I would say, Russia and Poland, they constitute the most contrastive cases within this, what I call the varieties of post-socialism spectrum. And now my research questions, so how these macro trajectories of post-socialist transformations were experienced and dealt with by practicing lawyers, and how do institutional differences and different paths of transformation impact professional orientation frames. This brings me to a few methodological consideration, which will also explain the concept of the professional orientation frame. So as I said, my general frame of reference is a theory of professional field or juridical field by Pierre Bourdieu and the concept of habitus, which is, however, linked to something that a German sociologist, whose name is here misspelled, it's just Bonsack, as some of you may notice, so there is one H too much in the name, and there is a typo, connects to something that he calls praxeological sociology of knowledge, which is then broken down into methodology of documentary method of interpretation. What does it mean? The Bonsack and following Mannheim distinguish between communicative knowledge, so knowledge which is well conceptualized and can be presented as kind of self-theories by most of the social actors, from something that he calls conjunctive knowledge. He sees a connection to the concept of tacit knowledge in Michael Polanyi. So this conjunctive knowledge results from practical experience, is very important for practice, but many actors have difficulties to present you a consistent theory how things are done, although they know very well how things are done in their field of activity. And of course, those of you who are familiar with the theory by Pierre Bourdieu see the parallel to the theory of practice. And the main goal in the work by Ralph Bonsack is the reconstruction of something that he calls social orientation frame, soziale Orientierungsrahmen, for those who know German. And these frames are based mainly on stocks of conjunctive knowledge of social actors. And then two colleagues, much older than me, Fritz Schütze and Arndt Michael Nohr, were very helpful in providing a very refined method of reconstruction, which combines the documentary method of interpretation with narrative analysis. If you are interested in this, we can delve into it, but I will now skip the more detailed demonstration and progress to a few sampling criteria before I acquaint you with my preliminary findings. So, how I sampled my interview. So first of all, I interviewed lawyers whom I call representing lawyers. So lawyers who represent someone, no judges, no prosecutors. You may ask why. First, these groups were most strongly impacted by the economic changes that took place during the post-socialist period. Second argument is that they are most numerous. And the third is very practical. I had this idea from the very beginning to do it, to study in Russia, and Russian colleagues told me it's extremely difficult to get in touch with Russian judges, and it's even more difficult to get in touch with Russian prosecutors, because Russian prosecutor's office is a very secretive organization. So I thought, well, if Vadim Volkov from Institute of the Rule of Law from St. Petersburg, European University in St. Petersburg, who did his research on different organized crime groups in the 1990s, tells me that it's very difficult to interview Russian prosecutors, I say, okay, I'm not trying to become a member of a suicide squad in more or less metaphoric sense, and I will stick to those people who are more accessible. So it was also a pragmatic decision. But beyond this, I also focus on two generations in Mannheimian sense. Life course sociologists would rather call them age cohorts. So one socialist generation, so people who went through their professional socialization during the socialist time. They were born mostly in 1940s and 1950s, and then a post-socialist generation, which is kind of my generation, so people born in 1970s and early 1980s. Also looked at different professional subgroups that I mentioned: advocates, legal counselors, in-house lawyers, and private practice lawyers in Russia, so those unlicensed lawyers. I looked at different domains of legal specialization, of course, male and female, and also into different regions. And in this moment, I have to express my gratitude to the German Academic Exchange Service, but also to the Higher School of Economics that this assignment in Moscow gave me a very good opportunity to travel in Russia and do a lot of field work. Okay, so I'll skip the details of the data set and I will proceed to the empirical findings, a typology of professional orientation frames. So first I identified something that I call basic professional orientations. They are like you have to imagine when we use this metaphor of the field, so they are like magnetic poles which exert, force into the juridical field. And an individual professional orientation frame is a kind of intersection or an interpenetration of different forces coming from these basic professional orientations. But often, as I realized, there is one dominant basic orientation which determines how other poles impact the specific case. So for example, a domination of justice orientation has an impact on client orientation. So justice-centered client orientation means that defending and representing rights of the clients are in the center, while income orientation assigns different meaning to the role of client in the professional client relation. I will expand on this in a few minutes. And professional orientation frames are, this is also very important to keep in mind, significant but only a part of general social orientation frames, so this soziale Orientierungsrahmen, but the later is broader. So professionals are human beings and members of the society, and they are involved in many other social contexts and circles, but there is an interpenetration between these two aspects. And I realized, for example, that creative self-fulfillment aspirations are particularly strong, especially in younger generation and in Poland more than in Russia. What I mean by creative self-fulfillment aspirations is that initially these people were rather interested in doing something like creative writing, fine arts, music. So for example, one of my interviews, his first wish and his first goal was to become a musician. He was fascinated for pipe organs, for church, Catholic music. He was from Poland, as you can suppose. And but unfortunately, he was consumed by stage fright. So it didn't work with concerts. So he studied musicology, Musikwissenschaft. Also dealt with medieval music, but then law became for him kind of let's say exit option from something that he realized it might be a biographic dead end street, and now he is a partner in the boutique law firm and specializes in intellectual property. It's a very interesting case, so maybe we will come back to this case. And a possible transformation is also a type of professional orientation frame which I call intellectual adventurous. So maybe we can also touch upon this topic later when I introduce the typology. So here is a graphic representation of how basic professional orientations impact the professional orientation frame. So what are the main poles? So it's justice orientation. I started with legal norms as a general point of reference, but then I realized that there is a difference between justice-oriented understanding of legal norm and rather formal technical, some would say very positivistic formalist understanding of legal norm. And sometimes there is a serious tension between these two understandings. And I think that the talk that Lawrence Solon gave a few days or 1 or 2 weeks ago here was a very good demonstration of one of this frame which was very strongly justice oriented. And I was thinking you could put these arguments, turn 180 degrees around, and it would be a very different type of legal professional you would have in front of you. Then, of course, clients. As I mentioned, I always interviewed people who were working from some kind of individualized social actors who seek professional advice and representation in situation of real or potential social conflict. Then material remuneration or income. That brings us back to this idea of making a living. You eat what you kill. Professional activities are gainful occupation. It's a translation I found for the German expression Erwerbstätigkeit. And of course, there is a strong link between remuneration and client, because clients are those who pay for lawyers' services, but there are also possible tensions, and it's not necessary that both orientations go hand in hand. So a justice-centered client orientation that I mentioned before is more focused on clients' rights than on what clients pay me and what they demand from me. And on the other hand, there is what I call a virtual type, because I have no real representative in my sample, but this type was mentioned by many interviewees, who is a juridical fraudster. So who is basically trying to use legal tricks to extort as much money from their clients as he or she is possible. So this would be an example where remuneration orientation rules and the client is unimportant. Then collective professional autonomy is also an important point of reference, being a part of a free, autonomous or liberal profession. Its public mission, its political role, especially in Polish cases, and also it's an occupational group that has to take care of its collective image, because the collective image has impact on market opportunities on individuals. And last but not least, the selves. Professional activities are believed to be linked to relatively high intrinsic rewards coming from practicing itself. It's intellectually challenging, and it's particularly attractive to a orientation type that I call intellectual adventurous. So they are excited to work on complicated, on intellectually demanding cases. Gratitude of clients, which is particularly important to a type that I call juridical caregiver. So where the role of the lawyer is taking care of clients who maybe are also depicted as somehow weak and in need of additional guidance. And competitive success, which is also something very important, especially for a type which I call courtroom performer or even courtroom fighter. Now I would like to demonstrate the intersection of professional orientation frames between these two two basic orientation, and I refer here to something that we already know, Lady Justice. We heard a very interesting talk on this topic a few weeks ago from Valérie. But there is also the lady client. I don't need theories from my lawyers, I need answers. So between these two poles, our interviewees operate. And here is something for those who are familiar with Pierre Bourdieu's work. You will find some similarity to this famous figure from Distinctions. However, I must admit it's not factor analysis, so it's not quantitative, it's not cluster analysis, it's just mapping of different types. And I also try to determine some, let's say, trends or some different poles in which different types of orientation move. So the ideal legal professional, I must admit, I struggle a lot with this description, but I wasn't able to find another expression for that. So some are really like this textbook ideal lawyers, but there are not so many, and there are many different other types around. But in this is of course two-dimensional, and as you remember, there are 6 poles, so you would have to imagine a 6-dimensional space, which is impossible to depict in our 3-dimensional world. But this is only just 2 dimensions. So the ideal professional, legal professionals are able to balance this tension between, on the one hand, client orientation, and on the other hand, justice orientation. And it's especially expressed in narratives about cases, because this is the main device that I use in practical empirical analysis. They emphasize the importance of clients' rights, and especially of procedural rights, which is something very specific to professionals. I mean, I also have cases mainly of people who went through rather little professional socialization beyond just studying law, who are rather focusing on the material side, on you know, that it's just injustice when certain things are done by certain actors and you have to do something about that. But in many cases, it's more about procedural rights. If you are interested in this, I have an appendix where I can demonstrate it on particular cases. Then we have another extreme where justice orientation and norm orientation is quite high, but there is little concern about what clients want. And I denoted this type as warden of the law. So this is the role of the lawyer, also described by some American colleagues in a study from 2000s as a cop lawyer. So basically, legal professional who always tells you it's prohibited, you can't do it, it's illegal, don't do it, don't do this, don't do this. So basically, that leads to a situation where in some companies there is a running gag reported by an American sociologist of the legal profession that the legal department is called the Department of Profit Prevention, because they basically you would have to shut down the company if you listen to especially this type of wardens of the law. Then in the middle there is the back office lawyer, who this is I think empirically I cannot make any inferences about how numerous these types are, because the study is not quantitative. But I suppose this one is quite numerous, and these are people who are just working mainly in salaried positions. They do what their bosses want them to do, and they are not very interested. I mean, they are somewhere in the middle in client orientation. I mean, justice is not unimportant to them, but it's also not something that they are very excited about. Another I think quite numerous type, and which is on the rise in post-socialist period, is of course the juridical entrepreneur, so who describes his or her professional activities as running a business. So all decisions from hiring associates to specializing in different domains of law are embedded in the economical logic. So the question is, do I specialize in real estate, or maybe it's better to do something with, I don't know, pharmaceutical market regulation? Do I specialize in arbitration? Is now very popular, but I think it's not just a trend in Poland and Russia. As far as I know, it's a quite international trend. So, but these decisions are seen from the perspective of economic logic, because you can look at, let's say, at arbitration and out-of-courtroom settlement of conflicts from a different perspective. Like, for example, juridical caregivers, they think rather, that you preserve good relations between different actors, and they emphasize very different aspects when they talk about this kind of conflict settlements. Then you have here the self-fulfillment corner. So here you have the courtroom performers, so people who are mainly interested in being a successful lawyer in terms of competing with other lawyers, mainly through participating in litigation. And their narratives are very dominated by this self-picture imputed into their narratives of them manipulating everybody and being able to always find the best solution. An important thing to notice on the methodological side is that it's not about if these stories are true or not, but it's important how differently they present themselves in the interview situation. And then we have here something where client orientation is high, but consideration of justice and norms are rather low. This is something I called, or it's not my concept, client capture. It's a concept introduced by two American sociologists, Leicht and Fennell, and it relates to the gatekeeper role of legal professionals. The legal professions are not just servants of their clients, but they have also responsibilities vis-a-vis the legal system, because once you become an accomplice of your client in doing illegal things, you kind of saw on a bunch of a tree on which you are sitting. And this kind of activity, which is described as client capture, is exactly this forgetting about the broader gatekeeper role, which is overemphasized here. So here is the pure gate, basically the warden of the law is closing the gate and not letting anybody in. And here they are willing to accept many illegal or not strictly speaking legal behavior by clients. That's, I would say, that's the difference between the hired gun who by himself or herself would not do something illegal, but can assist his or her client in doing things that are, let's say, at the very boundary of what is legal, while corruption broker is someone who gets involved in illegal activities mainly by participating in bribe transactions. A buddy lawyer is a very interesting type, and it refers to diversification of client capture concept that was introduced by Dinowitzer and two colleagues in a recent paper, where they say in complex situations, because lawyers as opposed to doctors can work for very differently structured clients, from single individuals to huge organizations, where you can have different actors within a complex organization with whom they can collude. And a buddy lawyer is someone who, so a good example is one of my Russian interviewees who works in a big banking corporation, and he's responsible for legal due diligence of candidates for loans. And he's good friends with some colleagues from the department which sells loans to clients, and they are of course interested in closing the deals, because if the deal is not closed because of some legal considerations about the potential loan taker, then they will not get their rewards. And the buddy lawyer is willing to, no, he would never recommend to give a loan to someone who definitely will default, but he's bending the rules in a very very delicate way, so more loans are awarded to clients of the bank, because it's for the benefit of colleagues from other departments who then offer him some kind of friendly help in other situations. So this kind of client, it's not a real client capture, because this employees of the banking company are not really clients of an in-house lawyer. They are employees of the other employees of the client. So this is what Dinowitzer and colleagues call misdirected client capture. So where in complex principal agent structures, lawyers become accomplices rather of agents of the client than of the client himself, of her or herself. So just because I'm running out of time, just to show you how it looks multi-dimensional, I'm not going to walk you through all these details. So it's basically where I try to, so here are the different types, here are the different basic orientation, and then I assess the degree, so minus and plus means high or low. And there are here different cases, so you can see that some types are built just on one case, and this is something we can discuss when you are interested in how, let's say, reliable it is in terms of qualitative methodology in our discussion. So let me jump to my conclusions and close this presentation before I violate the iron rule of the German academia, which you can only express in German. Man kann über alles reden, aber nicht über eine Stunde. You can talk about everything, but no longer than 1 hour. It's not funny in English, but in German it's funny, believe me. So, concluding remarks. So, justice orientation, I realized that in the older generation there is much stronger connection to political considerations, especially it's the case in Poland. So, a lot of justice considerations are linked to the character of the state socialist regime, while in the younger generation these political considerations are not so relevant. Client orientation and remuneration orientation are, I think, on the rise. It's also reflected in changing specializations and new categories of clients that emerged in the post-socialist period. We see a vast diversification of practice settings. I wasn't talking about that. If you are interested, I would be very happy to tell you more about this. In any case, I referred here to a study from the 1980s on Chicago lawyers by Heinz and Lohmann. So they say that the lawyers in Chicago live on 2 different hemispheres. In fact, there is no one single profession, but there are those who practice for private individuals and those who practice for corporation. I would say by now we are even moving further, and we have a even stronger diversification of the domains of legal practice. In Poland, there is also an interesting process. I mentioned the advocatization of legal counselors, but also some advocates are becoming more like legal counselors, which means that they work for big companies. They often don't go to courts. Some of them even say going to court is a defeat, no matter if you win or lose, because a good lawyer writes a contract which is not contested by anybody in the courtroom. So they focus on office-based work. They sit in negotiations. They are involved in mergers and acquisitions. So the courtroom work is rather delegated to other actors in the field. The typological variance is much higher in Russia than in Poland. And let me just jump briefly to this figure. So I would say that in Poland it's mostly here. So the back office lawyers, there are some courtroom performance, many juridical entrepreneurs, and some ideal legal professionals and juridical caregivers. And especially this area, and I realized that in the process of qualitative coding of my interviews, that, for example, calls for things like corruption, bribery, fraud, etc., were filled with quotations when I started to work with Russian interviews. And just for you to understand the background, I never ask about these issues, I never ask these questions. I ask the people to tell me the story of their lives and tell me about the cases they work on. And so basically these topics are brought to the table, into the interview by my interviewees. And I think that this much higher typological variance in Russia is related to, on the one hand, to differences in professional institutionalization and socialization, which I mentioned before, but also to the general frame of the post-socialist dual state. I use this concept here relating to Sakwa's book on this. And I also wrote a paper on this where I developed the concept of the bad fruit farm. If you are interested, you may ask me about it, but this is also something I'm going to talk at a presentation I was invited to by Katarina. It's, I think, sometime in early July, so I hope that many of you will find time and opportunity to listen to this talk, which is about professional misconduct by lawyers in the Russian Federation. And another thing which is maybe going beyond the professional aspect is a negative connotation of socialist past that I observe in Poland, while in Russia the Soviet past is, I'm sorry, I'm at the wrong slide. Soviet past in Russia is gets very diverse assessments, from very critical to very euphoric. One of my interviewees even described herself as a fan of the Soviet Union, ja fanat Sowieckiego Sojuzu, which even people who were members of the Polish United Workers' Party, they rather try to twist their biography in a way that it looks that they were in the party, but in fact it was somehow service for the national patriotic cause, and the circumstances were like that, so there is no such euphoric or positive assessment of state socialism in Poland. And I think this is what unites people in Poland despite the current conflict that we unfortunately observe. So thank you for your attention, and I'm looking forward to your questions.